Okay, I'm going to share screen. Can everyone see that okay?
Yes.
Jurors, can you guys all see that?
Yes.
Judge Purdy? Okay,
Yes.
I'm going to now read to you the charge of the court. You're going to get a copy of this when you, in your iPad. This will be sent to your iPad. It'll be in your Dropbox by the end of the evening. So, charge of the court, members of the jury. After the closing arguments, you will go to the jury room to decide the case, answer the questions are attached, and reach a verdict. You may discuss the case with the other jurors only when you're all together in the jury room, a virtual jury room. Remember my previous instructions. Do not discuss this case with anyone else, either in person or by any other means. Do not do any independent investigation about the case or conduct any research. Do not look up any words in the dictionary or on the internet. Do not post information about the case on the internet. Do not share any special knowledge or experience with the other jurors. Do not use your phone or any other electronic device during your deliberations for any reason. I'll give you a number where others may contact you in case of an emergency. Any notes you have taken are for your own personal use. You may take your notes back into the jury room and consult them during your deliberations, but not show or read your notes to your fellow jurors during your deliberations. Your notes are not evidence. Each of you should rely on your own independent recollection of the evidence and not be influenced by the fact that another juror has or has not taken notes. You must leave your notes with the bailiff when you are not deliberating. The bailiff will give your notes to me promptly after collecting them from you. I'll make sure your notes are kept in a safe, secure location and not disclosed to anyone. After you complete your deliberations, the bailiff will promptly destroy your notes so nobody can read what you wrote. In this situation, obviously, you guys would destroy your own notes. Number one, do not let bias, prejudice, or simply play any part in your decision. 2, base your answers only on the evidence submitted in court and on the law that is in these instructions and questions. Do not consider or discuss any evidence was not admitted in the courtroom. 3, you are to make up your own minds about the facts. You are the sole judge of the credibility of the witness and the weight to be given their testimony. But on matters of law, you must follow my instructions. 4, if my instructions use a word in a way that's different from its ordinary meaning, use the meaning I give you, which will be a proper legal definition. 5, all the questions and answers are important. No one should say that any question or answer is not important. 6, answer yes or no to all questions unless you are told otherwise. A yes answer must be based on a preponderance of the evidence unless you are told otherwise. Whenever a question requires an answer other than yes or no, your answer must be based on a preponderance of the evidence unless you are told otherwise. The term preponderance of the evidence means a greater weight of credible evidence presented in this case. If you don't find a preponderance of the evidence supports a yes answer, then answer no. A preponderance of the evidence is not measured by the number of witnesses or by the number of documents submitted in evidence. For a fact to be proved by preponderance of the evidence, you must find that the fact is more likely true than not true. 7, do not decide who you think should win before you answer the question. Then just answer the question to match your decision. Answer each question carefully without considering who will win. Do not discuss or consider the effect your answers will have. 8, do not answer questions by drawing straws or any other method of chance. 9, some questions might ask for a dollar amount. Do not agree in advance to decide on a dollar amount by adding up each juror's amount and then figuring the average. 10, do not trade your answer. For example, do not say, I will answer this question.
They're delivering my iPad.
Okay, we'll just take a quick break.
Yes, sir.
Yes, sir.
How are you doing, man?
I'm doing fine. How are you?
Well, so far, so good.
Good.
Now that I found you, I'm a lot better here. If I could get you to print your name here, your date of birth, and then sign for me right there, please. I even give you a tablet.
You're so sweet. You told me to print.
Yes,
No,
ma'am.
okay.
Print it and then sign below. But your handwriting's prettier than mine.
Thank you.
All right, ma'am, are you back?
I'm writing slow.
No problem. Thank you very much,
Thank
ma'am.
you, sir. You have a blessed and
Good
safe
luck
day.
with all that.
Thank you. I'm
All right,
back.
Ms. Irving. All right, so I think we were on number 10. Do not trade your answers. For example, do not say, "I'll answer the questions your way" if you answer another question my way. 11, unless otherwise instructed, the answer to the question must be based on the decision of at least 10 of the 12 jurors. This is very important. The same 10 jurors must agree on every answer. Do not agree to be bound by a vote of anything less than 10 jurors, even if it would be a majority. Definitions and instructions. Negligence means the failure to use ordinary care. That is, failing to do that which a person of ordinary prudence would have done under the same or similar circumstances, or doing that which a person of ordinary prudence would not have done under the same or similar circumstances. Ordinary care means that degree of care which would be exercised by a person of ordinary prudence under the same or similar circumstances. Proximate cause means a cause that was a substantial factor in bringing about an event, and without which cause such event would not have occurred. In order to be a proximate cause, the actor which is complained of must be such that a person using ordinary care would have foreseen that the event or some similar event might reasonably result therefrom. There may be more than one proximate cause of an event. You are instructed that a fact may be established by direct evidence, by circumstantial evidence, or both. A fact established by direct evidence when proved by documentary evidence or by witnesses who saw the act done or heard the word spoken. A fact established by circumstantial evidence when it may be fairly and reasonably inferred from other facts proved. Question number 1. Whose negligence, if any, of those listed below do you find proximate cause of collision made the basis of the suit? Answer yes or no for each of the following. Minwara Ansar, Hector Escobar. Answer question number 2, only if you have found in your answer question number 1 that the negligence of more than one of those proximately caused the collision. Otherwise, don't answer question number 2. Question number 2, what percentage of negligence that caused the collision do you find to be attributable to each of those found by you in your answer question number 1 to have been negligence? Assign percentage of responsibility only to those you found caused or contributed cause the occurrence. The percentage you find must total 100% and must be stated in whole numbers. The negligence attributable to a person is not necessarily measured by the number of acts or omissions found. Answer by stating the percentage of any opposite each name. Minwara Ansar, Hector Escobar, total 100%. Question number 3. Answer question number 3 if you answered yes for Minwara Ansar to question number 1 and no for Hector Escobar, or 50% or less for Hector Escobar to question number 2. Otherwise, don't answer question number 2. What sum of money, if paid now in cash, do you find would fairly and reasonably compensate Hector Escobar for the injuries of any that resulted from the occurrence in question? Consider the elements of damage listed below and no others. Consider each element separately. Do not include damages for one element and any other element. Do not include interest on any amount of damage you find. Do not include any amount for any loss existing before the occurrence in question, except to the extent, if any, that such loss was aggravated by the loss that resulted from the occurrence in question. Answer separately in dollars and cents for damages, if any. 1, physical pain and mental anguish sustained in the past. Answer. 2, physical impairment in the past. Answer. 3, medical care expenses incurred in the past. Answer. Presiding juror. When you go to the jury room to answer the question, the first thing we need to do is choose presiding juror. Presiding juror has these duties. Have the complete charge read aloud if it will be helpful to your deliberations. B, preside over your deliberations, meaning manage the discussions and see that you follow these instructions. C, give written questions or comments to the bailiff who will give them to the judge. D, write down the answers you agree on. E, get the signatures for the verdict certificate. And F, notify the bailiff that you've reached a verdict. Do you understand the duties of the presiding juror, everybody? Give me a thumbs up if you understand it. All right. Instructions for signing the verdict certificate. 1, and this is really important. Unless otherwise instructed, you may answer the questions on a vote of 10 jurors. The same 10 jurors must agree on every answer in the charge. This means you may not have one group of 10 jurors agree on one answer and a different group of 10 jurors agree on another answer. If 10 jurors agree on every answer, those 10 jurors sign the verdict. If 11 jurors agree on every answer, those 11 jurors sign the verdict. If all 12 of you agree on every answer, you're unanimous and only the presiding juror signs the verdict. 3, all jurors must deliberate on every question. You may end up with all 12 of you agreeing on some answers, while only 10 or 11 of you agree on other answers. But when you sign the verdict, only those 10 who agree on every answer will sign the verdict. Do you understand these instructions? Everyone
Yes.
understand? Give me a thumbs up if you understand. So if it's unanimous, and I'll show you the next form. Martin Hoffman, Judge Presiding, 68 District Court, Dallas County. Verdict certificate, check 1. Our verdict is unanimous. All 12 of us agree to each and every answer. The presiding juror has signed the certificate for all 12 of us. Signature presiding juror, printed name of presiding juror. Our verdict is not unanimous. 11 of us agree to each and every answer and have signed the certificate below. Our verdict is not unanimous. 10 of us agreed to each and every answer and have signed the certificate below. To be signed by those ready to read the verdict, if not unanimous. Juror signatures, juror's printed name. So let me just go through something really important here, and I'm going to go into a little more detail than I usual. You see this form here? Can everyone see it okay? How many people here have ever worked with Adobe Sign? Give me a thumbs up if you've worked with Adobe Sign. You have Miss Williams? Anybody else? Miss Brumley, okay. And I see another juror. Okay, number 7. Okay, so the way you're gonna be filling out this form when you're a juror. Okay, so when you're deliberating, you reach a verdict, you're going to fill out an Adobe sign version of this piece of paper, okay? So if the verdict is unanimous, then the presiding juror will have an Adobe sign, and you'll click next to where it says, our verdict is unanimous, okay? All 12 of us agreed to each and every answer. The presiding juror signed the certificate for all 12 of you. And then the presiding juror will do Adobe sign to sign right there. Does that make sense? So it's unanimous, everyone agrees, only the presiding juror signs with Adobe sign. If it's not unanimous and 11 people agree, then you click with Adobe sign right here where it says our verdict is not unanimous, 11 of us have agreed. If it's only 10 of you, our verdict is not unanimous, 10 of us have agreed and have signed the certificate below. It's very important on how you click that because that will determine how the Adobe sign program works. And so, does everyone kind of understand that, how this form works? Okay. So I'm going to stop sharing this and I want to kind of talk to the jury. For those watching on YouTube, we're going to reconvene tomorrow at 9:30 to finish the trial and do closing arguments and then the jury deliberation.